Benefits of a revocable living trust in Georgia.
There are many benefits to using a revocable living trust as your primary estate planning document in Georgia. Some benefits, like avoiding probate, are easily explained. Others, like incapacity planning and minimizing post-death disputes, are more nuanced. For more information, working with an experienced Atlanta living trust lawyer can be helpful. At Trace Brooks Law, we can walk you through the different benefits of a revocable living trust and how it can be a useful addition to your estate plan. Contact us today at 404-492-9559 to schedule a consultation.
Added privacy by avoiding probate.
In Georgia, a will must be filed with the probate court of the county where the decedent resided, as well as any ancillary probate courts. Revocable living trusts, on the other hand, are private documents that are not typically filed with any court and therefore do not become public records. To take advantage of the added privacy that a revocable living trust provides, you must fully fund your trust.
Avoid out-of-state probate.
A revocable living trust can be a valuable tool to help you avoid probate if you own or may acquire real property outside your state of residence. In general, a will must be probated in each state where you own real property at your death, in addition to the state of your primary residence, even if you do not own property in that state. However, if your out-of-state property is owned by your revocable living trust, there is generally no need to probate your will in that state because the property owner, the trust, has not passed away. By using this ownership structure, the trustee of the revocable living trust can more quickly and cost-effectively transfer title to the intended beneficiaries. To take advantage of this benefit, you only need to transfer your out-of-state real property to your revocable living trust.
Incapacity planning.
A revocable living trust can be an essential tool to ease the burden on your loved ones if you become incapacitated.
Unlike a will, a revocable living trust can provide protection both during life and after death.
With a fully funded revocable living trust, the management of your assets during your incapacity and after your death becomes much simpler for your loved ones. While it may take some additional initial effort to fully fund your revocable living trust, it can be well worth it to ease the burden on your loved ones. As the legal owner of the trust assets, a trustee of a revocable living trust has an easier time managing the assets in question than someone acting under a power of attorney. The trustee's legal authority makes it easier for banks, government institutions, and other third parties to accept and recognize the trustee's authority. Declining mental and physical function commonly occurs later in life and is often imperceptible at first. Many aging people go through a period of several years where they are not fully incapacitated but have decreased mental capacity and make increasingly poor decisions. A revocable living trust can help prevent others from taking advantage of you during periods of declining cognitive capacity by preventing you from engaging in harmful or ill-advised transactions.
Avoid post-death disputes.
A revocable living trust can be a valuable tool to avoid post-death disputes, especially for those with complex family situations or those who wish to distribute their assets unequally or to non-family members.
Legal disputes often arise when family members or other beneficiaries disagree with the distribution of assets outlined in a will or trust.
By using a fully funded revocable living trust, you may curtail these disputes because assets owned by the trust do not go through probate, making it more difficult for disgruntled family members to challenge the distribution of assets. Further, it is generally more difficult to successfully challenge a trust than a will.
Ease of moving to another state.
For individuals who may move to another state, revocable living trusts offer greater flexibility and cost-effectiveness than wills. While states generally recognize wills created under the laws of another state, updating a will-based estate plan to take full advantage of the probate and estate administration laws in a new state can be a costly and time-intensive process. Revocable living trusts, however, avoid this issue, as a well-drafted trust contains all the necessary provisions, regardless of state of residence. Therefore, only the standard and less expensive powers of attorney and pour-over will need to be redone upon moving to a new state.
Easily make and change specific bequests.
Georgia law allows individuals to make specific bequests of tangible personal property such as artwork, collectibles, and jewelry before the remaining assets are distributed. A revocable living trust allows for the creation of a schedule of specific bequests that can include any type of property, including money, without the need for an attorney's assistance. Therefore, creating and modifying a schedule of specific bequests in a revocable living trust is cost-effective and can be done at little to no cost without the help of an attorney. You should, of course, advise your attorney of any changes to your specific bequests.
Handling incapacity through revocable living trusts.
When a person establishes a revocable living trust, they are planning not just for the certainty of death but also for the possibility of becoming unable to manage their own affairs. In such cases, a successor trustee, whom the trust maker designates during the creation of the trust, can step in seamlessly to manage the trust's assets. This transition avoids the often cumbersome and public process of court-appointed conservatorships or guardianships. The role of the successor trustee is to manage the trust's assets according to the terms laid out by the trust maker, who is also commonly referred to as the grantor or settlor. This can include paying bills, making investment decisions, and taking care of the trust maker's needs, all without the delay or interference from the courts. It's a dignified way to maintain control over one's assets and care through a trusted individual or entity.
To use a corporate fiduciary as your agent under your power of attorney. While most corporate fiduciaries are hesitant to serve as agents under your power of attorney, some are willing to do so if they are also named as the successor trustee under your revocable living trust. If you become incapacitated, the corporate fiduciary would use their authority under the power of attorney to transfer your assets to your revocable living trust, where they will serve as successor trustees. How much does a living trust cost in Georgia? The cost of setting up a living trust in Georgia can vary significantly based on the method you choose for creating the trust. Using an online platform to draft the trust document by yourself is generally the most cost-effective approach. Typically, this method will cost you less than a few $100s. Such platforms often provide templates and guidance, but they lack the personalized advice and knowledge of a legal professional. On the other hand, if you decide to hire an attorney to assist with the creation of your living trust, the expenses are considerably higher. You can expect to pay more than $1,000 when working with a legal professional. The exact fee can vary depending on the lawyer's experience, reputation, and the complexity of your estate planning needs. While the DIY route may seem financially appealing, it comes with risks. The process requires meticulous attention to detail and a substantial amount of legal research, which can be daunting and error-prone for those unfamiliar with estate planning. Given these complexities, hiring an attorney is generally recommended to ensure that the trust is set up correctly and tailored to your specific circumstances. Always inquire about the attorney's fees early in the process to manage your budget effectively and avoid any unexpected costs. Understanding the costs and intricacies of establishing a living trust can be complex. At Trace Brooks Law, our experienced Atlanta living trust lawyer Trace Brooks can guide you through every step of the process, providing clarity and efficiency. We offer personalized advice tailored to your unique situation, helping you understand all associated fees and making the process as transparent and straightforward as possible. Contact us today at 404-492-9559 to schedule a consultation.